It is now my distinct honor to introduce our chief guest for this evening, Honorable Justice B.V. Nagarathna, Judge of the Supreme Court of India. Her ladyship's journey at the bar and on the bench reflects a deep and unwavering commitment to constitutional values. Her jurisprudence consistently reminds us that our Constitution is not merely a legal text but a living instrument. Through her scholarship, clarity of thought, and steadfast emphasis on constitutional morality, her lordship has enriched the discourse on rights, governance, and the enduring strength of the basic structure doctrine. Ladies and gentlemen, we are truly privileged to have our ladyship with us this evening. I now respectfully invite Honorable Justice B.V. Nagarathna to deliver the Justice T.S. Krishnamurti Iyer Memorial Oration and to formally inaugurate the continuing legal education program of the Kerala High Court Advocates Association.
Namaskar and a very good evening to you all. Honorable Justice Somen Sen, Chief Justice of High Court of Kerala, my esteemed brother and sister judges of the High Court of Kerala and also a brother judge from Madhya Pradesh, Justice K.M. Joseph, my esteemed former colleague, and Justice Syriac Joseph. I think he thought of Justice Anna Chandy and Justice Fatima Bibi when he recommended my name to the Karnataka High Court. Learned Advocate General Sri Gopal Krishna Kurup, members of the family of Justice T.S. Krishnamurti, Sri Iyer, Sri Balaji Murthy and Srimati Usha, Advocate Sri Piyush Kottam, President Kerala High Court Advocates Association and other office bearers, Advocate Roy Chacko, who has given the felicitation today, learned senior advocates and members of the bar. I see learned senior advocates from Delhi as well as from Kerala, distinguished invitees, members of the media, ladies and gentlemen. I must thank Mr. Balaji Murthy and Srimati Usha and their family for inviting me to deliver this second Krishnamurti Iyer Memorial Oration today. I begin by paying my tribute to Justice T.S. Krishnamurti Iyer, an eminent judge who dedicated his life to upholding justice and equality. Born on 14 June 1911 at Trivandrum, he began his career as an advocate in 1935 and practiced in the Travancore High Court in Trivandrum and later the Kerala High Court in Kochi for several years. In 1965, he was appointed the Advocate General for the Government of Kerala, which soon thereafter was followed by his elevation as a judge of the Kerala High Court in the same year. During his tenure as a judge, Justice Iyer earned a reputation of being fair, impartial, and committed to upholding the rule of law. We have just heard speaker after speaker telling us about it. Following his retirement, Justice Iyer established a thriving practice as a senior counsel in the Supreme Court, and he appeared in many landmark cases. He appeared in Mithilesh Kumar versus R. Venkatraman, where the presidential election of Mr. R. Venkatraman was challenged. And incidentally, I must say that matter was before my father, Justice E.S. Venkatramaya, because 5 judges are supposed to hear a challenge to a presidential election. And he succeeded there. Kerala Hotel and Restaurant Association versus State of Kerala, Union of India versus K.S. Subramaniam, and the celebrated Bijo Emmanuel versus State of Kerala, where he appeared along with Sri Pali Nariman, and where it was argued on the rights and freedoms under Article 25 and Article 19(1)(a) of the Constitution. There are many more cases, but due to paucity of time, I have limited this to the few cases I have referred to. Later, Justice H.R. Khanna invited him to be a member of the Law Commission. and he contributed as a member therein. Apart from his contributions in the public sphere, Justice Iyer was known for his humility, kindness, and compassion. He was a role model for many, and his legacy will continue to inspire generations to come. I thought, having regard to the personality and the life and career of Justice Krishnamurti Iyer, I would select a topic on which deals with essentially on the constitutional values and ideals, and I have named it Transformative Constitutionalism and Basic Structure Doctrine, a Dialogue. At a first blush, it may appear to be contradictory, but I have tried to reconcile the two doctrines. The Constitution of India emerged as a culmination of many decades of struggle and anti-colonial rule. Its deeper orientation is in fact historical because it is preceded by the conditions that shaped our Constitution. Societies are not blank slates at the moment of constitutional adoption. They are layered with histories, institutions, discriminations, traditions, and they cannot be just swept away by a new constitution as such. It is having taken note of this caveat that transformation in the Indian context corresponds to two historical legacies of injustice which prevailed prior to the adoption of the Constitution. The first way in which Constitution was transformed was in the relationship between the individual and the state. India became a republic. It was no longer a colonial regime. Apart from universal adult franchise, which is so relevant today, and representative democracy, this transformation was expressed in fundamental rights enforceable against the state. The Indian Constitution was transformative in another sense. It contemplated a thorough reconstruction of the society too. As I already stated, deeply pervasive hierarchies were maintained by structures that took various forms, caste being the principal among them, but also gender, class, race, etc. This recognition is also reflected in the horizontal rights of the fundamental rights. I need not elaborate to this enlightened and erudite audience about Article 15(2), Article 17, and Article 23, which I can just highlight. It is important to also note the genesis of the term transformative constitution. The term has become a part of the constitutional discourse since the making of the Constitution of South Africa in 1996. Incidentally, it is going to complete its 3 decades this year. Perhaps one of the most widely accepted explanation of the term transformative constitutionalism is offered by the American academic Carl Clare in his book titled Legal Culture and Transformative Constitutionalism, where he writes, and I quote, "Transformative constitutionalism connotes an enterprise of inducing large-scale social change through non-violent political processes grounded in law." That is what our Constitution is, was, and shall ever be when we adopted it on 26 November 1949. The dominant approach of interpretation underlying constitutionalism is that it was not meant only for the 1950s, but it is a living tree, so dynamic that it is always evolving with the decades. The living tree approach has been invoked, for instance, to justify the expansive rights under Article 21 or even Article 14 for that matter. Transformative constitutionalism recognizes that the framers were building a constitution meant to last for generations and not for a limited period. We all know as to the vehicles or the organs of the Constitution through which the transformative agenda operates, that is through the legislature or the parliament, through the executive, and through the courts. The transformative vision of the Constitution of India can be broadly understood through three themes within the Constitution. For paucity of time, I am only concentrating on these. First is the Equality Code contained in Articles 14 to 16 of the Constitution. Second, the Fraternity Code declared most clearly in the preamble. And finally, and third is the Constitution's Liberty Code in Articles 19 to 22. The Equality Code. The post-colonial Indian state was highly conscious of the necessity to address looming issues such as poverty, illiteracy, untouchability, and gender inequalities. Recognizing the importance of law as a catalyst for social change and the significance of rights in remedying the harsh iniquities of the past, the Constitution has emphasized the importance of universal rights of equality and non-discrimination. Second, fraternity, which is, in addition to the values of liberty and equality, fraternity as a leveling instrument has been clearly stated in the preamble, which will reverse the socialization of biases, discrimination, and power dominance in society. It signals a commitment to a political community in which differences of belief, identity, and practice do not translate into either domination or civic exclusion. Fraternity's constitutional role must be carefully understood. Its force lies not in command, but in orientation. It is a day-to-day practice for all of us. It must preserve the space for persuasion, social change, and democratic deliberation. This is especially significant in order to deepen our democracy and its values. Coming to liberty, it is one of the most elementary goals of transformative constitution, which is to ensure freedom of the individuals. We know about A.K. Gopalan versus the state of Madras and the limited interpretation that was given by the Supreme Court in 1950. But in 1978, in Menaka Gandhi versus Union of India, the court stated that a procedure which meets the mandate of Article 21 was still subject to the challenge under Articles 14 and 19. This broad interpretation has become the starting point, a springboard for a spectacular evolution of law relating to personal liberty in various cases. Meaningful transformation presupposes a robust domain of individual freedom within which private persons can act, choose, and dissent without justification to the state. The thinning out of personal liberty, often in the name of collective or public interest, must be guarded against. Transformation in this sense presupposes a restraint. This insight directs attention to the constitutional mechanisms that exist precisely to enforce such restraint. Among these, the basic structure doctrine occupies a distinctive place. It is the site at which the Constitution most explicitly articulates limits on the exercise of power, even when the power is claimed in the name of the Constitution itself. The origins of the basic structure doctrine in the Indian context lay in the founding moments and the early years of self-rule. We all know at that time the Parliament was concerned with the reform agenda to abolish the then prevailing zamindari system. Since independence, questions were raised in legal academia and before courts about the scope of the Parliament's power to amend Part 3 of the Constitution, which constitutes the fundamental rights. I need not go into the details of it, but in Shankari Prasad Singh Deo, the Supreme Court said that Article 368 empowers the Parliament to amend the Constitution without any exception. and that the fundamental rights are not excluded from the scope of Article 368. The same position was affirmed in the next case, that is Sajjan Singh. But Justice Mudolkar in Sajjan Singh's case has brought in the famous expression, basic features. He expressed doubt as to whether certain basic features of the Constitution, to which the framers intended to give permanency, could be amended as well. Then what would be left of the eternal values of the Constitution then? He questioned whether such amendment would amount to rewriting the Constitution. The first event in the saga leading up to the formulation of the doctrine occurred in 1967, when the Supreme Court held in Golaknath that the Parliament had no power to alter any of the fundamental rights enumerated in Part 3 of the Constitution, even by way of a constitutional amendment. The Parliament responded to the judgment in Golaknath by amending Article 368 itself, by enacting the Constitution 24th, 25th and 29th Amendment Acts 1971. The Constitution 24th Amendment Act purported to abrogate the rule in the Golaknath case and to restore the power to amend the fundamental rights. Since I am speaking on the soil of Kerala, I thought the controversy with regard to the Keshavananda Bharati case must be highlighted, and therefore I selected this topic. The immediate question before the Supreme Court in Keshavananda Bharati was whether Parliament possessed unlimited authority to amend the Constitution, including the power to alter or abrogate fundamental rights. In resolving this question, the court rejected both extremes. It refused to hold that the Constitution was entirely unamendable. The amending power was recognized, but it equally declined to accept that the amending power was plenary and uncontrolled, so that one day the entire Constitution is amended. Instead, it articulated a structural limitation. While Parliament could amend any part of the Constitution, it could not alter its basic structure. The verdict in Keshavananda Bharati case can be found in 11 separate judgments. But then there was a statement, a seminal concept which was signed by a few of them, called the basic structure of the Constitution, which renders the same immune to amendment by the Parliament. Chief Justice Sikri, who was presiding over the 13-judge bench, identified 5 basic features. First, supremacy of the Constitution. Second, republican and democratic form of government. Third, secular character of the Constitution. Fourth, separation of powers between the legislature, the executive, and the judiciary. Fifth, federal character of the Constitution. Justice Shouldnt and Justice Grover spoke about the unity and integrity of the nation and the importance of the directive principles of state policy. Justices Hegde and Mukherjee identified a separate list of basic features, while Justice Jagan Mohan Reddy spoke about the preamble of the Constitution itself being the basic feature. The Indian judiciary and the polity, as well as constitutional scholarship, to this day are consumed by the magnificent innovations created by the 11 opinions in the historic verdict of Keshavananda Bharati. The many varied and profound questions it raises, the place of judicial review in a democratic society being, according to me, the principal among them. Later, of course, the doctrine was applied and cemented in the case of Minerva Mills, Vaman Rao, S.R. Bommai, where secularism was spoken of, and I.R. Coelho. I do not wish to elaborate on all these judgments, but I must say that from the outset, the basic structure doctrine was conceived by the Indian judiciary as a response to a specific structural anxiety that the judges had then. A written constitution, if fully amendable, risks collapsing into an ordinary statute. We have seen repeal and there being a repeal of statute and reenactment. Sometimes there is only a repeal and there is no reenactment. That cannot happen to a constitution. Yet a constitution that cannot be amended risks obsolescence. Equally significant is the doctrine preserves certain transformative principles such as constitutional supremacy, republicanism, equality before law, and liberty that gives coherence to a constitutional order across time, decades, and centuries. By marking the boundaries of permissible change, the doctrine creates the conditions within which questions about the Constitution's transformative commitments can be meaningfully asked. Thus, according to me, transformative constitutionalism is concerned with how the Constitution works over time. The basic structure doctrine is concerned with how far it can be altered. One speaks the language of aspiration, and the other the language of limits. Very simply put, the basic structure tells us what must not be lost. Transformative constitutionalism explains how those commitments are meant to endure. One secures the Constitution against annihilation. The other ensures it does not harden into irrelevance. Today, I propose that transformative constitutionalism and the basic structure doctrine speak to each other in the following ways. There may be many more ways, but I could identify only these. First, the basic structure doctrine identifies the constitutional minimum. It marks those foundational commitments: liberty, equality, dignity, rule of law, constitutional supremacy, and above all, judicial review, without which the Constitution would lose its identity. Its role is essentially negative. It tells us what constitutional change must not destroy. Second, transformative constitutionalism supplies the constitutional trajectory. It explains how those foundational commitments which the basic structure doctrine identifies are meant to operate across time. Its role is dynamic rather than prohibitory. It guides how constitutional values are to be realized, deepened, and made meaningful in practice over decades. Third, when read together, the basic structure doctrine disciplines transformation, and transformative constitutionalism animates the basic structure doctrine. Transformation is constitutionally legitimate only insofar as it advances basic structure values, rather than hollowing them out. At the same time, the basic structure avoids becoming a doctrine of inertia by recognizing that fidelity to constitutional identity may sometimes require change rather than mere preservation. Finally, this dialogue clarifies the limits of both. Transformative constitutionalism cannot be invoked to justify erosion of negative liberty, dilution of habeas corpus, or normalization of coercive power, because these strike at the very restraints the basic structure exists to protect. Equally, the basic structure cannot be invoked to freeze constitutional meaning at the moment of enactment, because a constitution committed to justice cannot be indifferent to the condition of its own application. In short, the basic structure secures the Constitution against destruction. Transformative constitutionalism secures it against moral exhaustion. Together, they describe not a conflict, but a constitutional method of enduring through principled change. The connection between transformative constitutionalism and the basic structure doctrine, therefore, is intellectually coherent. One supplies direction, the other supplies restraint. The question then is not merely whether transformation and structure can be reconciled in principle, but who ensures that transformation does not become destruction, and also that structure does not ossify into stagnation. If transformative constitutionalism is to operate within the outer limits supplied by the basic structure doctrine, there must surely be a constitutional actor capable of policing those limits. That actor is the judiciary, exercising the power of judicial review. Without judicial review, the basic structure doctrine would be a mere constitutional slogan. Courts, on the other hand, translate abstract commitments, liberty, equality, dignity, the rule of law into actionable claims. Thus, both basic structure doctrine and transformative constitutionalism converge institutionally in the judiciary and its important role. One as a guardian against constitutional self-negation, the other as an engine of principled constitutional development. However, judicial review can discharge this dual function, giving effect to the transformative spirit of the Constitution only if there are two things: separation of powers on the one hand and independence of judiciary on the other hand. First, on separation of powers. The logic of the basic structure doctrine articulated in Keshavananda Bharati assumes that Parliament's amending power is limited and that it is for judiciary to determine when that limit has been crossed. I need not remind this enlightened audience about the case surrounding Indira Nehru Gandhi versus Rajnarayan, where the Parliament attempted to immunize the Prime Minister's election from judicial scrutiny, but the court's ability to strike down that attempt depended entirely on its structural independence from the political branches. This principle was recently affirmed by the Supreme Court in re directions in the matter of demolition of structures. The court was confronted with a troubling practice: the demolition of homes by executive authorities on the mere basis that the occupants stood accused of wrongdoing. The court clarified the constitutional boundaries in clear terms. Determining guilt is a judicial function that would require adjudication on the basis of evidence and adherence to due process. If the executive demolishes a citizen's home merely because an accusation has been made, without trial, without findings, without following legally prescribed procedures, it effectively assumes the role of a judge. That collapses the constitutional scheme. Separation of powers is the architecture that ensures the executive does not adjudicate, the judiciary does not administer, and the legislature does not execute. Where these lines are respected, constitutionalism survives. Where they blur, arbitrariness would trump. Next, equally crucial is that judicial review must be underwritten by judicial independence. Independence secures the capacity of courts to articulate and defend constitutional commitments against transient political will. Judicial review frequently requires courts to invalidate legislation, restrain executive action, or set aside constitutional amendments enacted by political majorities. These are not easy tasks for the judges or for the courts. They often carry political consequences. Even if judges know that unpopular decisions may cost them elevation, extension, or bring them in the bad books of the powers that be, that should not come in the way of decisions. Ultimately, it is the conviction, courage, and independence of a judge which really matters. We as judges should always follow our oath of office, which is our judicial dharma, and live up to it irrespective of its consequences on our career. The best example we have today is of Justice H.R. Khanna, who was keen to uphold the Constitution during the most difficult period of our history, even at the cost of being overlooked to the highest judicial office in the country. Otherwise, judicial review becomes symbolic, exercised cautiously, selectively, or not at all. I would say, as a result, even judicial accountability would suffer. Let me say that we judges, we should unite for the cause of justice, for we have nothing to lose except our independence. I would repeat this. Let us judges unite in this country for the cause of justice, for we have nothing to lose except our independence. And once we lose our independence, we cease to be judges. There are temptations looming all over, but according to me, the shortest word and the shortest sentence in English language is no, N-O. Whatever be the temptations, just say the word no, and there you are clear in your mind and for all times to come. Security of tenure insulates judges from retaliation. Transparent and structured appointment processes reduce partisan capture. How we appoint our judges, whom we choose as our judges, what is the extent of neutrality the recommended candidates have, these are all very relevant in these days. Institutional autonomy, administrative and financial, prevents indirect nudges of pressure. These safeguards do not make judges infallible, but they make principled adjudication possible. Ultimately, the true content of judicial independence is realized not in institutional design alone, but in the manner in which judges discharge their office. For this, there are two other aspects. First is independence from external influence. A judge must be free from political pressure, institutional intimidation, or popular demand. Second, and more subtly, independence also operates within the judicial institution. It also requires that each judge be free to express his or her considered view of the law, even when that view diverges from colleagues. Separate and dissenting opinions are manifestations of intellectual autonomy. This is independence of the judiciary in its most enlightened form, according to me. If the law, as we understood it, requires clarity, even bluntness, then dilution for the sake of consensus is a form of compromise we should be unwilling to make. In this way, the relationship between transformative constitutionalism and the basic structure doctrine is not merely conceptual, but it is institutional. Their complementarity presupposes judicial review, and judicial review presupposes separation of powers and judicial independence. Strip away judicial review and the doctrine becomes only a slogan, advisory. Only within a framework of separation of powers and judicial independence can transformation remain constitutionally bound. Democracy is dedicated to liberty and equality. Without the judicial protection of individual rights against their encroachment, the preconditions of liberty and equality would fall. It is this arrangement, a transformative vision guided and bounded by the basic structure limits and enforced through independent judicial review within a system of separated powers, that ensures constitutional continuity in the midst of change. In conclusion, I would say it is thus possible to draw a principled connection between transformative constitutionalism and the basic structure doctrine, despite their seemingly divergent orientations and apparent contradiction. Transformative constitutionalism appears aspirational, animated by the promise of deep social change, while the basic structure doctrine appears conservative, concerned with preservation. Amendment, after all, is the mechanism through which a constitution admits change. But if everything can be amended, then nothing is constitutional. The constitution dissolves into ordinary politics then. Transformative constitutionalism gives the constitution a moral and historical trajectory. The basic structure doctrine ensures that this trajectory does not become indistinguishable from rupture. Together, they reflect a constitutional imagination that accepts change as necessary but not limitless, an imagination that recognizes that transformation without structure risks arbitrariness, just as structure without transformation risks stagnation. On that note, I conclude my lecture. I thank you all for your kind attention. But before I actually conclude, I must say that I am happy to inaugurate the program of continuing legal education, which has been taken up by the Bar Association. I commend your efforts in instituting the continuing legal education program, which plays a vital role in strengthening the bar's engagement with complex legal issues in various emerging areas of law. In a rapidly evolving legal landscape, whether it's in insolvency, bankruptcy, restructuring of companies, maritime law, intellectual property, or other specialized fields, continuous learning is very essential. Such initiatives not only enhance professional competence, but also ensure that as practitioners of law, you remain equipped to address sophisticated legal problems with clarity and depth. We as judges are always looking for clarity in submissions and citing of correct provisions of law and not be blown away by the AI. At the same time, the nuanced use of artificial intelligence must be thought of by the bar associations. What methods you would have to see that the judgments which are cited or the positions of law which are cited are correct and true. That instead of citing the provisions and sections of the Act, the commentaries are not cited as taken from the AI. We all know earlier, as advocates, we did not have all these facilities. To search for a judgment, we would go for the Quinquennial Digest, AR Manual, or the Supreme Court Digest. Now, by a click of a button, if you click one word, you will get 100 decisions. Now, how are you going to cite all that? It becomes it becomes totally impractical. Therefore, I would say that please go to the read and read and read every provision of law that you are citing or you are advancing, because every time you read a provision of law, you would get a new insight. I am getting new insights in the Supreme Court on CPC, which I have been studying for almost 40 years. So therefore, I would advise and suggest to our young friends and advocates to read the provision of law every time you have a case. Read the commentaries on it. We have very great commentators of law which are time tested, and therefore you must read the commentaries on the provisions, dissect the provisions, then go to the case law and to the correct case law and not to imaginative case law, and cross-check that there is such a citation in the reputed legal journals such as the AAR, SEC, and what have you, and thereafterwards cite the judgments before the courts. Otherwise, there is an additional burden on us judges that whenever cases are cited in the law courts, we have to ask somebody to see whether those judgments really exist, whether those quotations really exist, because in Supreme Court, we have had personal experiences where judgments cited do not exist and where quotations from Supreme Court judgments do not exist. Therefore, I request the President of the Bar to have a separate discussion on the use of AI in practice and to best assist the courts with the help of AI. I thank you all for your kind attention. I hope I have not tested your patience. Thank you once again to Mr. Balaji Murthy and his family. I thank the Kerala Bar Association for inviting me. And last but not the least, I thank Honorable Chief Justice and each one of you for your kind attention. Thank you and namaskar.
Thank you so much, Your Ladyship, for that masterful dialogue and for those profound insights. To conclude this formal session, I call upon Sri Balaji K. Murthy for the vote of thanks.